The United States. Plaintiff Appellee versus Ah Chong. Defendant Appellant. GR number L-527, March 19, 1910, on Bank, Justice Carson. The facts of the case are as follows. The defendant Ah Chong worked as a cook, whereas Pascual Gilberto, the victim, was a houseboy. They shared a room with a door that did not have a secure lock. A chair was put against the door as a measure of security. Around 10 p.m. on August 14, 1908, Ah Chong was disturbed awake by someone attempting to force open the room door. He sat up in bed and shouted out twice, "Who is there?" He received no response, and the noise at the door persuaded him that this was being forced open by someone intent on pushing his way into the room. Fearing that the intruder was a burglar or a robber, the defendant got his knife and struck the intruder as it entered the room. It turned out that the said intruder was his roommate Pascual, who was pranking on him. Despite his plea of self-defense, the court of first instance found the defendant guilty of homicide. The issue here is whether or not the defendant Ah Chong, by reason of mistake of facts, will be held criminally liable. The Supreme Court reversed the decision of the lower court and held that the defendant must be acquitted. The court held that there is no criminal culpability when one commits an offense or act due to ignorance of facts, provided that it was not due to negligence or bad faith. A mistake of fact resulting from self-defense, which is a justifying circumstance under the revised penal code. The elements of self-defense are 1. Unlawful aggression, 2. Reasonable necessity of the means employed to prevent or repel it, and lastly 3. Lack of sufficient provocation on the person defending himself. On the other hand, the requisites of a mistake of fact to be invoked as a defense are 1. That the act done would have been lawful had the facts been as the accused believed them to be, 2. That the intention of the accused in performing the act should be lawful, and 3. That the mistake must be without fault or carelessness on the part of the accused. The defendant committed an act that would have exempted him from criminal culpability if the facts were as he believed them to be. That is, if the person was actually a burglar, the defendant would not be held liable, for that would be a case of self-defense, in accordance with the law. In this case, defendant acted in good faith, without malice or criminal intent, and also cannot be held guilty of negligence or recklessness, as the facts as he saw them was a threat to his person and properties. Actus non facit reum nisi mens sit rea. The act itself does not make man guilty unless his intention were so. Actus me incito factus non est meus actus. An act done by me against my will is not my act. The essence of the offense is the wrongful intent, without which it cannot exist. Because evil intent is an essential component of all crimes, any factual error demonstrating that the act done was not motivated by evil in the mind absolves the actor of criminal guilt, provided there is no fault or negligence on his side.